I'd like to introduce Eric Guthrie. He's the Director of Training and Programs here at GBA and has been since the beginning. Yes, absolutely, since the beginning. He's the best-selling author of Blockchain or Die and Diversify or Die. Eric is also an attorney with the Cogent Law Group, is an international speaker, and has led training programs all over the world. Let me introduce you to Eric Guthrie.
Okay, good morning. For those of you who know me, I hate being behind a podium, so I'm trying to pull this thing out. We have a fun panel. There we go. All right. We've got a fun panel coming up. We've had some meetings beforehand, and we're looking forward to presenting to you, engaging with you. So without further ado, I'm going to call them up by name, starting with Alexander Zul. Round of applause. Okay. Thank you. Nabil Malik. Nabil. Kevin Lowell. And Mike Kanovitz. So our panel is the state of blockchain and the law. And this morning, we're going to spend, was it 3 hours, Brian? How long do we have?
4 hours.
4 hours discussing blockchain and law with you. And we're looking forward to engaging with you. So I'm going to do, this is how we're going to start. I'm going to have them introduce themselves because I cannot do them justice. I'm going to have them spend a minute, tell you all what they do. Then I'm going to kick the panel off, and then we'll go into some questions. So let's start with Alexander.
Thank you, Eric. Hi, guys. My name is Alexander Schul. I'm one of the co-founders of a company called Rome Blockchain Labs, and we develop Web3 decentralized finance technology. So we've launched several lending markets. We have liquid staking services. We've done execution engines, pretty much anything on decentralized networks, you name it. So on this panel, I'll probably be coming from the Web3 perspective and really helping add context to a lot of this discussion.
Okay, Nabil.
Hi guys, my name is Nabil Malik. I am the CEO and founder of Cryptolytics. We've owned and managed a mining data center. More recently, we've shifted over to just managing a small hedge fund because mining has become more enterprise level, and we'll discuss that more in detail as it goes on. Thank you.
Okay.
Good morning, everybody. I am Kevin Lowell. I am a trial attorney with the Department of Justice Fraud Section here in Washington, D.C., and I serve as the cryptocurrency coordinator for the Fraud Section. And in that role, I manage the crypto enforcement program, and I focus on investigating cases involving fraud, all manner of financial fraud, and market manipulation in the digital assets space. And I'm excited for a lively discussion about all things blockchain and the law.
And Mike.
Good morning, I'm Mike Kanovitz. I'm a practicing attorney in Chicago, and I'm also a co-founder of the company called Jurat Blockchains. And what Jurat is doing is we are connecting courts to blockchains and smart contracts so that people can go seek rulings from courts, enforce legal rights, and have those rulings execute either through a smart contract or at layer one on a blockchain automatically, and also importantly without any intermediary in the middle between the court ruling and the nodes or the smart contracts that are acting on the court rulings.
Okay, and that's our panel. So I guess a few things about me. This is the Blockchain or Die that Bryant was talking about, Amazon #1 bestseller 4 times, 3 book awards. And also I have a course called the Blockchain Legal Specialist course, which is given 7.5 CLEs by the DC Bar, and is good in 45 states. So if you're an attorney and you want to get some CLEs, come see me and we'll get you in a GBA course. But now let's see who's in the audience, okay? How many of you are attorneys? Please raise your hand. Okay, we got a few attorneys. How many of you own a blockchain company? Raise your hand. Okay, excellent. How many of you are here because you're curious about blockchain technology or cryptocurrencies? Raise your hand. Okay. How many of you are here from the education space, colleges, universities, things like that? Raise your hand. Okay. All right, so we have a pretty good mix around the room. You guys got that?
Yep.
Okay,
Yep.
Excellent. We're going to start with the disclaimer, and that is as follows. The viewpoints of the panelists are their own, and unless specifically stated, do not represent the views of their corporations or agencies to which they are affiliated. So we have to make sure that we cover all our bases here with all of our panelists and myself for that matter. And now we're going to start with a quick opening statement to kind of kick it off for all of you. Currently, legal systems are based on centralized governance and control. Centralized businesses, centralized laws and regulations, and centralized accountability. So the question is, how does the legal system that's built on centralized everything adapt for a decentralized space, right? And that's something that the legal system right now, from courts, legislatures, agencies, they're all grappling with. So this panel here is going to solve all those problems in 1 hour, right, guys? There you go. All
40
right.
minutes.
40 minutes.
40 minutes. 40 minutes. There you go. So we're going to go to our first question, and we're going to go to Kevin. From your perspective, what are some of the key legal issues facing the digital asset industry and the blockchain space today?
Thanks, Eric. Look, I think there are a couple of key issues that are facing the industry and what we can anticipate in the next year. Number one, the role of the federal regulators and agencies in shaping the regulatory landscape. How are each of the key enforcement agencies, the SEC, the CFTC, DOJ, how are all these agencies going to shape the law through their enforcement actions? What kind of cases are they going to pursue? What area of the crypto ecosystem are they going to focus on? The second issue that I think is going to be key, particularly over the next year, is this concept and application of digital asset classification. How are these regulators thinking about these various digital assets? How do we take existing law, existing legal frameworks, and apply them to new innovations in crypto and blockchain? Some of the questions that come up frequently in these fact patterns: am I dealing with a security? Am I dealing with a commodity? Is this institution operating as a money services business? And all those questions are critical because they relate to the risk that those companies face, and they also relate to the legal regime that those companies have to abide by. The third and sort of like key thing is the extent to which Congress passes comprehensive legislation that covers the waterfront in the crypto industry. There are a number of key bills that are now pending and have been introduced. Some of those bills, for example, give significant authority to the CFTC, so that could have a significant impact on the regulatory landscape over the next year. So it's going to be a combination of the role of the regulators in shaping the landscape, how they classify digital assets through those enforcement actions, and the role of Congress in coming up with a comprehensive framework for the industry.
Anything, Nabil?
So I'm going to look at it from a different perspective, right? I think the biggest problem in the industry as we speak right now, especially from a regulation perspective, is that the government does not understand cryptocurrency, right? You can say this is very obvious currently with the SEC case with XRP right now. They initially labeled it as a security, took it off all the US exchanges, and now they're slowly losing the case. I just think the current framework does not equip any agency to deal with or regulate cryptocurrency. I believe there should be a brand new branch or a new agency which has smart people that are well-versed and educated in cryptography and the technology to manage and regulate the industry. The old rules do not apply here. And I'll give you an example, right? Traditionally, stocks, if you say one company is fraudulent or it's a scam, you just delist it from Wall Street and nobody can purchase it. That's not true with cryptocurrency, right? XRP was at this moment, even from a US government perspective, they've said it's a security, all the exchanges have delisted it, but you can purchase it from your peer. You can still purchase it from another exchange. So even if the US government today decides to ban Bitcoin, you still cannot take it out of your country because it's decentralized and you can purchase it from a neighbor or somebody sitting right here, right now.
Well, even the guy next to you on the panel. So I think that's actually a pretty poignant observation. There's a bit of a dichotomy that hasn't yet been resolved, at least in our experience at Rome Blockchain Labs, where there's on one side the regulation of some asset, right? If you can classify something as a security, it falls under the securitized framework, and then you can implement some enforcement around that. The problem is that doesn't really work in decentralized markets, just like Nabil was saying. Just like you can't shut down a cryptocurrency when you get to decentralized finance exchanges and such, you can't delist anything off of a decentralized exchange. Not even the founders of the decentralized exchange can delist something off of a decentralized exchange. Now, there are practical steps you can take such that you can perhaps limit it from being accessed on the front end. So when you go to that website, you can't see that asset. But as more platforms are becoming aware of this, and as many already are, they're transitioning to decentralized front ends. So now the website itself is decentralized in addition to the smart contract. So what do you do when as a regulator, you've said, all right, this asset can't be bought or sold in the US, it has to be shut down, but we can't shut it down, we can't shut down the exchange or anything else that's supporting that. It's, your hands are kind of tied, not because you don't know what to do, you just can't do it. So that's where I think that rather than running wholesale with this fully decentralized approach, it is wise to take a step back and actually understand that regulations exist for a reason. They exist to protect investors and consumers. They exist to maintain fair markets. And in a lot of cases, you don't necessarily have that in decentralization. Our laboratory did some research a couple months back, and we found out just in 2022 alone, on the top 3 decentralized exchanges in the world, Uniswap v2, Uniswap v3, PancakeSwap on BNB chain, over 40% of every single token pair on there was a scam or a copy. Think about that. If you went to the NYSE, you had a coin flip opportunity for finding if it was a legitimate token or not. That's a big problem. That's a really big problem. Now, the number is high, and typically what happens, I'll kind of condense the activity, is that whenever I list an asset on a decentralized exchange, like a legitimate token, anybody else can take that ticker and then list a scam contract with the same name but a different address at the same time. So somebody who's unaware of what's going on, who's unaware of what exactly the legitimate project is, can go into the exchange, see a pool with that right liquidity, buy it, they buy the scam token, I get their legitimate assets, I pull the plug, so to speak, on the pool and walk away with their money. There's nothing anybody can do about this. And this happens all the time. So that's why regulation is important. That's why, at least for me personally, I think that developers in the space should go hand in hand with regulators to figure out how can we make this work to make these markets fair.
Yeah, following up on the point about how do you go about enforcing the law in any sort of decentralized environment, it's really starting to get interesting. For the last 4 years or so, there's been this tug of war between the industry and regulators, with the industry saying we need special rules for decentralized services, and with the regulators saying, decentralization is no excuse for not following the law, figure out how to do it. And now we're starting to see enforcement actions actually happening against decentralized services. And it's pretty fascinating. Over the summer, we had the Treasury sanctions against Tornado Cash. And basically, because it's a smart contract and the addresses are at least pseudonymous, nobody knows who's using it. And so Treasury sanctioned the address itself and therefore the wallets that touched those addresses. And we know many of the users of Tornado Cash are using it for legal purposes, but there are people who are using it for legitimate privacy purposes. And so, it becomes interesting because we have a constitution, and the Constitution has a due process clause, and the due process clause that says that the government can't affect your property interests without giving you due process of law. And here we are with the government basically making the crypto that anybody put through Tornado Cash unusable. They've ruined a property right. Now, I'm not saying that that is unconstitutional in this context, because what is the government supposed to do in that situation? And maybe the people who are using Tornado Cash, should realize that when they put, even if they're not doing it for an illegal purpose, when they put their coins through a mixer, they are helping people who are using it for an illegal purpose to launder money. And so that's going to be a big issue. And another data point that we just got this week, the CFTC brought an enforcement action against a truly decentralized DeFi platform. And what the platform does is like most DeFi platforms, it accepts crypto, it locks it up in a smart contract, and then it lends you something against it. It might pay you interest, or this one in particular would lend a type of currency many of you have probably heard of called DAI. They would do it, again, with these anonymous addresses. And the CTFC looked at it and said, you know what, your decentralized protocol is providing margin, which is something that the CFTC regulates. And on top of that, you are providing these financial services without going through KYC and AML. And they said that's a violation. So they bring the lawsuit, the enforcement action against the protocol, and this is something that anybody who's participating in one of these protocols as a coin owner should pay attention to. The CFT says that the decentralized platform is an unincorporated association that is violating the law, the CFTA, through the owners who own the governance tokens, because those are the owners who are deciding how the platform should run. And you know, as far as I know, that is the first time that the government has taken a look at a decentralized system and said, there's still owners here. Those owners are affecting policy, and those owners can be liable for owning those tokens. I think that will come as a shock to most people who are participating. If you bought shares in Coca-Cola, you would have an ownership interest in Coca-Cola, but if Coca-Cola violated the law, you know, you can sleep soundly. The government can't come after you for that. So the law that's going to govern how the law gets enforced is going to be very interesting to follow.
Indeed it will. Okay, so I'm going to queue up the next question for you guys. How many of you know about the executive order passed by the Biden White House on cryptocurrencies? Okay. How many of you know about the recent regulatory framework that the White House published? Okay. Just to give you a little bit of a background, this is the fact sheet, and I'm going to read a portion of it to you so that way you'll understand the question and the panelists can give you some good answers to the question. The White House released its first ever comprehensive framework for responsible development of digital assets. The digital asset, God bless you. The digital asset market has grown significantly in recent years. Millions of people globally, including 16% of adult Americans, have purchased digital assets, which reached a market capitalization of $3 trillion last November. Digital assets present potential opportunities to reinforce U.S. leadership in the global financial system and remain at the technological frontier. I'm going to skip down. Over the past 6 months, agencies across the government have worked together to develop framework and policy recommendations to advance the 6 key priorities identified in the executive order: consumer and investor protection, promoting financial stability, counterfeit illicit finance, U.S. leadership in the global financial system, and economic competitiveness, financial inclusion, and responsible innovation. All that being said, here is the question for the panelists. As soon as I can find the question. Here we go. This is the mic, starting with Mike. Just this month, the White House released its regulatory framework for crypto, which I just read part of it to you. What is your quick take on that framework?
Rewinding back to March, I think it was March when we got the executive order, that looked really, really optimistic. You know, the White House was talking about supporting innovation, the importance of U.S. leadership in the world in blockchain, and how we have this opportunity at this moment in time to take advantage of the fact that so much of the technology emanates from the U.S. and establish our position. And then it ordered the agencies to do their work, and we come back, and now we see what the working groups have come back with, and they're looking at it, and yes, they do want to see American leadership in the world of blockchain, but then they're also looking at Luna, and they're seeing, you know, $600 billion wiped out, you know, real people's money, not just you know, VC money, you know, small people, to whom, you know, their losses could mean everything that they have, and I think they're really struggling, and I do think that consumer protection being an important part of what the executive order was about, we'll see restrictions that will do, some disservice to innovation.
Anybody else?
I personally thought it was confusing. I mean, it's still confusing, right? I agree with Luna and how $600 million disappeared, but that happens on Wall Street all the time, right? I mean, there's an SOS company that was Chinese that hit $10, it's back under $1. There's multiple companies that have gone down 90, 80%. But I guess the question is, where do you draw the line in the new decentralized world? Do you just hold individuals and citizens accountable for the choices they make and the research they do behind their investments? Or when does the government step in, or should they ever step in to protect consumers?
Yeah, I think this is really reflexive of the shift in the nature of financial markets in business ownership. I mean, just that CFTC fee that they've put on, was it BZX? Was that the group?
There was a centralized founders, it was easy to go after them, but then they unleashed it as a completely decentralized platform, and so it's 2 enforcement actions.
Gotcha, thank you. And the executive order itself, I remember reading through it after it came out, and it was a little high level, so I don't think it was super distinctive, but it's kind of meant that way, because if you read through all of the different sections of that executive order, they were calling on essentially every single executive commission and agency to align unilaterally to figure this out. You have the DOE, you have not just the SEC and the CFTC, I mean, you get the FTC in there. Basically, every single commission has been told, figure out how blockchain technology, by extension cryptocurrency, applies to your area, and then how we can apply that over the coming years. I do think that the priorities as they were set out were actually pretty common sense. It was optimistic, to say the least, and I actually don't think that the injunctions put forward by the SEC or the CFTC have been particularly dissuading, in my opinion. What we've seen is that a lot of the fees that were put out were rather on the small end. I mean, it was a $250,000 fee from the CFTC. Really not that much money in the grand scheme of things for a DeFi platform when you have tens of millions or hundreds of millions of dollars in TVL. At the same time, excluding the cases that were particularly fraudulent and underhanded, in a lot of instances, they said, listen, just register as a security, and you won't have to pay a $10 million fee. You pay a small fee, register, and then you're golden. In my mind, that's about as friendly as you can get with Gary Gensler. You really can't ask for more there. So I do think that there is a mediated approach being taken here to, one, not seem like the bad guys, and two, not to scare people off.
Yeah, and just to follow up on that, I think there were a couple key takeaways from the White House crypto framework. Number one, it didn't set forth any sort of mandates, right? What it did is it called upon the federal enforcement agencies to aggressively enforce their laws and legal regimes against fraud and abuse in the market. The second thing it did is the White House said it was going to consider, and I think this is significant, recommending to Congress that it amend the Bank Secrecy Act. The Bank Secrecy Act, as many of you folks know, applies to financial institutions. Think of banks. And what it does is it requires those banks to adopt a Bank Secrecy Act anti-money laundering compliance program. You've got to know your customer, you've got to have a risk-based compliance program, and you've got to do due diligence on your customers. What the White House said was it was recommending that the Bank Secrecy Act be expanded to be applied to digital asset trading platforms as well as NFT platforms. So we could be in a world where NFT platforms and digital asset exchanges are now subject to the Bank Secrecy Act, where they have a duty and obligation to get to know their customer. Balancing that emphasis on enforcement and compliance was also a recognition of the need, back to my friend Nabil's point, for the government to work collaboratively with private industry, to offer up a dialogue and to promote a dialogue between the public sector and the private industry to understand the tech and the legal regimes that tech implicates, right? It's important for the government to understand it, but by the same token, it's important for folks in the private sector to understand it. So I thought it was a balance. It was for sure a broad sort of framework, but I thought it was a balanced framework that emphasized enforcement as well as dialogue with private industry.
Yeah, so my 2 cents, the one thing I do like about it is that, for years, the House and Senate were passing they were introducing them, not passing them, different bills, different regulations, and they weren't getting passed, but they all did something different. This is the first time I saw the government actually pulling together different agencies to say, let's work together. The issue, I think, this is to Nabil's point, is that they don't have an agency overseeing all this. And if they had someone with the expertise and the knowledge and the technical ability to oversee it, not just the White House itself, because, face it, the White House is a pretty busy place, right? But if they had an agency overseeing it, then they could probably do a lot more and accomplish a lot more and understand it a lot more, to all the panelists' point, as opposed to just putting out a statement or, an enforcement action and then seeing where it goes from there. All right, next question. Let's start with Nabil. What are the legal gray areas, and trust me, there are plenty, that could most benefit from regulatory clarification?
I think around blockchain and cryptocurrency, I think everything's great. I'll give you an example, right? I manage a hedge fund and I have clients. They ask me all the time about capital gain tax, right? Around cryptocurrency. One year, the IRS decided to give out a 1099-K. Usually that's given when you own a corporation, not when you own assets and you sell them. The following year, none of my clients got any 1099 from any of the exchanges. So I believe the laws are malleable, right? They're changing and they're not defining one set of concrete regulation that people can follow. I have clients that want to pay tax or want to follow the law, but at the end of the day, they're just confused on how to go on about it. And I think that will just happen with time. The more the IRS understands it, the more DOJ understands it, more they get educated. I think we'll have laws that come out that would help consumers, not confuse them. And just a side note, guys, with the Luna thing that I was hearing about, if you're getting 8, 10, 15, 20% for farming and staking, there is risk associated with that. Remember that. The more, you can call it interest, you can call it staking, you can call it farming, you can call it profits, whatever you want to call it. The higher that number is on your cryptocurrency, the more risk that blockchain and that project is at, because they have to meet those numbers on a constant basis. So don't think of, I think part of Luna's problem was their staking rewards were too high, or XYZ what happened, but whenever there's a high interest payout, the risk is always higher.
Excellent point. Anybody else?
I think part of the problem why we have such a gray area is because we're talking about crypto as a single homogeneous thing, and it's not. Crypto adapts to all walks of life. And so the path to regulatory clarity, and we're starting to see it happen, is to really differentiate between what these coins are doing, and particularly in stable coins, which are a payment mechanism. They can substitute for the Visa network. It does seem like regulators are focusing in, and the Luna crisis is a reason why their attention came to it, but at least with stablecoins, we're seeing an acknowledgement that they are a special category and that we can fairly quickly enact regulation to address it.
Okay, good point. Anybody else before we go to the next question? No? All right. And just so you know, we'll be taking questions from the audience in a few minutes. So think about your questions, and then when we're ready, we're going to call on questions from the audience. So start turning them around in your head. Next is Alexander. How should the Department of Justice and other agency regulators engage in effective enforcement while not stifling innovation? Alexander.
That's a question of the hour. So I think when you look at the question of effective enforcement, I think the first step would be to, one, delineate or define a scope around which you have a rock-solid case. I mean, any good lawyer does that, I'd have to imagine, is that you pick the cases wherein you have decisions that are unethical, irrespective of the technology. Because at the bottom of the bottom line here, all the problems we're facing with fraud, unsustainable growth in a lot of situations isn't because the technology is bad, it's because the people are greedy behind it. I mean, blockchain and cryptocurrency wouldn't exist if we didn't have the 2008 collapse. That's why Bitcoin was made, so there could be no manipulation of a virtual currency. I think if you can target the instances where developers, teams, be they centralized or decentralized, are particularly fraudulent, then yes, that's a slam dunk case. And you also communicate to the larger development community, hey, listen, we're not the bad guys here. We're looking to weed them out. We want to support proper development. That way they can go ahead and approach the proper agency or commission without any concern. Like there was a case, for example, it was a company a couple of years back called DMM and /DMG. They had 2 tokens. And they were going to launch crypto assets that were supported by car loans, kind of like a mortgage-backed security, but a car loan-backed security in this instance. They raised a whole bunch of money, issued the tokens, they never actually bought the car loans. So irrespective of having to, or bought the car loans, irrespective of having to register as a derivative, they never actually followed through, and they got persecuted, or not persecuted, prosecuted, excuse me. It depends on who you ask, there was persecution, I don't think so. They got prosecuted by the SEC, got slapped with a big fine, and went on their way. Those are cases that no matter how much of a degen, DeFi, crypto enthusiast you might be, no one says that's a wrong thing. You're never going to stifle innovation in that instance. When you have that type of action paired with progressive clarity around regulatory frameworks, then you can effectively enforce without worrying about stifling innovation.
Absolutely. Any other thoughts on that?
So I agree with that, and I think it's not a binary choice. There is a way to strike a balance between aggressive enforcement and the need for innovation, right? And in terms of enforcement, you focus on the worst actors in the space. And the way that you do that is you look at folks who are exploiting the public's interest and excitement for crypto, for blockchain, for DeFi. And you look at how many victims are associated with those cases. You look at the financial losses. These are real significant losses that are being caused to consumers and investors. And these are not institutional investors. In most of these cases, they are retail investors, regular folks who are looking to develop an additional stream of income. So you have to engage on the enforcement side in aggressive enforcement against the most egregious actors in the space. And by doing that, you can provide room for innovators, for companies, for entrepreneurs to develop tech. By the same token, you also have to engage, picking up on the spirit of that White House framework, with collaboration with the private industry to understand the tech on both sides, right? So the tech industry can understand the law, and folks in government can understand the tech and how it implicates the law. But I think you can strike a balance between the two.
And what I find interesting when I read these SEC enforcement actions, and there's $10 million, $20 million, $30 million actions against them, I think if you spent $50,000 and registered your security with the SEC, you wouldn't be in this mess right now. So, to your point, the enforcement actions and the balance also could be helped up by the people that are actually doing the work and the technology. They can make it more reasonable for everybody by actually registering their security and being in compliance. And they wouldn't have as many issues. All right, so we're going to go to a question and answer. We'll have the first gentleman come up front, and we'll hand you the mic so everyone can hear you. Okay, got it. That's okay. Martin.
Hi, I'm Marty LeClaire. I'm a money manager, and what I'm going to ask you about, I don't own this, nor do my clients. But in terms of protecting the little guy, the SEC, to my mind, has made a decision that's puzzling, and that is years ago, Greystone or GBTC, they came out with a closed-end fund that owns Bitcoin. And Grayscale. And it's a closed-end fund. I think it charges like 2.5%, 3% annual fee. And there's been lots of innovation. And what they want to do is convert into a exchange-traded fund in which the existing owners would see their annual fees drop by like 200 basis points. And the SEC won't let them do it. I know they're suing the SEC, so I know you probably can't comment, but perhaps you could explain their position and then get comments from the, because to me, it seems like if a little old lady wants to take a flyer on Bitcoin, this would be the perfect vehicle. You know, it's regulated, it's protections, they're not crooks, all that.
So unfortunately, you guessed right. I cannot comment on behalf of the SEC, but I appreciate the question.
Any other panelists? Okay. Well, unfortunately, I think we're out of time. I see the big hook coming, so let's give a round of applause to our panelists.